Welcome back to the house. Today we are going to continue with our discussion about negligence. And speaking of which, is getting these videos done later than I had hoped for negligent? A mistake? An error? A simple reality rooted in my life circumstances? A consequence of things like maybe forgetting to push record the last time I went through the whole video? How do you know when it's negligent? Well, at this point, you should know. You should be able to identify the key aspects of a negligence claim. That a duty of care is owed, that the standard of care has been breached, and that there is causation both factually and legally. And for factual causation, you need to be familiar with the but-for test. Remember, it asks, but for the actions of the defendant, would the plaintiff have been injured? If the answer to this question is no, then the defendant would have factually caused the loss or harm. If the answer to this question is yes, then the defendant isn't a factual cause. Now, this can at times be very complicated and a very complex determination, and it often hinges on the specific facts and the circumstances, including what's expected of the standard of care, which, as we've discussed, carries a lot of weight in negligence cases. So let's focus on how this might arise in an informed consent decision. Because negligence can arise in how a practitioner obtains, or as the case may be, fails to obtain an informed consent. You are well aware at this point that the Healthcare Consent Act imposes obligations on providers to ensure that they obtain a full and informed consent from a patient. The standard of care becomes very relevant in informed consent cases as it asks whether or not a professional has met the standard of care required in the disclosure of that information. To put it another way, it is recognized that all providers have a duty to obtain an informed consent to the treatment, and that requires that the elements that both the Healthcare Consent Act and the common law require, such as the discussion of risks, benefits, alternatives, etc., and to assess whether the health professional actually met this expectation. Now, if the health practitioner did not provide the proper information to obtain the informed consent, they might be found to be negligent. However, and importantly, the failure to provide information on its own is not enough to be negligent. It only demonstrates that the standard of care was breached. The standard of care is to obtain an informed consent. Failure to obtain that is to not meet the expected behavior. And this is now where the but-for test comes in. You have to ask to determine factual causation, but for the failure to provide the information required to obtain an informed consent, would the patient have been harmed? If the answer is yes, then the provider cannot be yet negligent. While they might not have obtained a proper informed consent, which is a breach of the standard of care, they may not have been a factual cause. But for their actions, would the injury have still occurred? Yes, they're not a factual cause. And this might be better understood by looking at a case known as Reibl and Hughes. The plaintiff in this case was Mr. Reibl, a man 44 years of age. Side note, that's so young. So young. He underwent a serious surgery to remove an occlusion in his left carotid artery that has prevented more than 15% of blood flow through the vessel. Now, importantly, the operation was successfully completed. That is to say, it met the standard of care. There was no question about the surgery. There was no negligence in the surgery. However, at some point during or following the surgery, Mr. Reibl had a massive stroke, and this left him paralyzed on the left side of his body and left him impotent. Now, while he admitted to having consented to the procedure, Mr. Reibl claimed that he was not informed about the risk of the stroke. So here the court considered what was required for the disclosure of risk. And as you're aware, the courts have regularly affirmed that there is a duty to disclose all material risks, and any risk that is serious, even if it's a minor possibility, should be disclosed. So for example, if there's a risk of, say, death or paralysis, even if the chances of that occurring are minute, it is now a material risk requiring disclosure. So the question the Supreme Court was weighing in Reibl is, how specific must the information to the patient be to enable him to make an informed choice between surgery and no surgery? Now, before we go on to discuss what the court decided, it's probably important that you go and take a look at this decision. You don't need to read it all, and in some ways I would say you shouldn't, because it probably won't help. But it does demonstrate how a court may assess things, as it has multiple issues at play. It reviews the evidence and shows you some of the transcripts, etc. And it's a good example of how courts may come to a decision. After reviewing the evidence, the court came to the conclusion that the plaintiff was told no more or understood more than that he would be better off to have had the operation than to not have had it. And importantly, the court held that this was not an adequate and not a sufficient disclosure of the risk attendant upon the operation itself. Dr. Hughes did not tell Reibl about the risk of the stroke, something he admitted to. And in his own transcript, he often would say that the chances of paralysis were greater for Mr. Reibl without the operation than with it. In other words, he felt that doing nothing was a greater risk than the surgery. However, the court found he did still not disclose the risk, and this amounted to a breach of the standard of care because Dr. Hughes is required to disclose all the material risks and did not. But that factually caused Mr. Reibl's stroke? Here is where the but-for test comes in. And the court notes that a reasonable person in the plaintiff's position would, on a balance of probabilities, have opted against the surgery rather than going at it at this particular time. In other words, but for the failure of the disclosure, would Mr. Reibl have gone forward with the surgery? No. And therefore, Dr. Hughes was responsible. First, this is the court actually assessing with that but-for test. But for the breach of the standard of disclosure, would the plaintiff have undergone the surgery which led to harm? And the answer is no, and the court identified several reasons why. First, Mr. Reibl was 1.5 years away from reaching a pension benefit from his job. And had he known about the risk of the surgery that might result him in not being able to do his job, i.e. a stroke causing paralysis, he would not have said yes to the surgery. He wouldn't have consented. The court also noted that Reibl wasn't in a state where action was immediately required. There was no emergency, no neurological defects. And in fact, Mr. Reibl thought that the surgery would actually relieve ongoing headaches, which was a mistaken belief on his part. And given that he consented to the surgery on these benefits, that it would end the headaches, had he known that wasn't the case, he wouldn't have consented. He would have likely delayed the surgery. And he would have especially done so had he been properly informed of the risk of a stroke. Thus, here the court found that but for Dr. Hughes's breach of his standard of disclosure, Mr. Reibl would not have been harmed. Now, what's interesting about this case is the language the Supreme Court used, because it represents a significant shift. The but-for test historically has relied on the reasonable person test. We have talked about this, the reasonable person standard, because it's a very important standard in law. It's an objective assessment. It doesn't ask what a specific person would do, and for good reason. Consider what would have happened if the court had asked, Mr. Reibl, if you knew that you would be paralyzed by a stroke if you had this surgery, would you have gone forward with it? The answer would have obviously been no. Nobody would choose to be harmed. So instead, the court seeks to answer this in an objective manner. Would a reasonable person in this same situation have consented to the surgery if they had known about the risk of the stroke? But you might notice and think, wait a minute, didn't the court consider specific factors relevant to Reibl alone, such as how many more years until he could qualify for a pension at his job? Is that part of an objective assessment? Well, it's not, which is why the court wrote it this way. It was assessing what a reasonable person in the plaintiff's position would do. Now, this has been called the modified objective or a subjective objective test. It still isn't asking what Mr. Reibl himself would do. It remains an attempt to be objective, but imports into the calculus the idea of the subjective context of the person. After all, a reasonable person would likely be impacted by their subjective position. Now, all term we've discussed how courts find their way to an answer. So here the court made major law changes to the law of informed consent to ensure that it could take into account specific factors relevant to Reibl, that would not have been considered in a basic objective reasonable person assessment. Now, Gerald Robertson, one of my former law professors and for many years Canada's leading malpractice scholar, notes that this decision really changed the law in two important ways. First, it established that the reasonable standard of disclosure is based on what the reasonable patient and not the reasonable physician would want disclosed. Which is to say, the standard of disclosure is based on what a reasonable patient would want to know, irrespective of whether a physician would have disclosed it or wanted to disclose it. So it didn't matter that Dr. Hughes didn't think it was relevant to disclose. The fact that it was relevant was a determination from the patient perspective. But the case also shifted the test for causation, creating the modified objective or subjective objective test. Now, this may seem like an overall win for patients, but what was the actual impact of Reibl? According to Robertson, 10 years and then 20 years later, patients lose, and badly. Now, before we get into some of the challenges with access to justice and why this is the case, let's look at a couple other examples of how this plays out in this space. In Turkington and Lye, the defendant surgeon operated on the plaintiff to remove a cyst on her left ovary, but proceeded to remove both ovaries because of the condition in which he found them during the surgery. During this process, he nicked the plaintiff's bowel, which resulted in post-operative complications that necessitated 80 days of hospitalization. The plaintiff sued and claimed that the surgeon was negligent in recommending and conducting the surgery and failed to inform her of the risk of nicking her bowel. Now, the court held that the surgeon here had acted reasonably in recommending and performing the operation, giving the plaintiff symptoms and conditions. The evidence of the plaintiff's expert that the operation was unnecessary wasn't given very much weight by the court because it wasn't supported by the information the expert reviewed or by any medical research or clinical studies. The court also here rejected the plaintiff's claim that there was a lack of an informed consent. The surgeon had informed the plaintiff of the 5 general material risks in any gynecological operation, including bowel injury. But the court held the surgeon was not required to disclose the specific risks of nicking the bowel because the chance of this happening was but 1 in 100,000. In essence, the court concluded that the risk was not material, but it described it as not being a serious material risk. And the surgeon here was not required to explain the option of doing nothing because the plaintiff's ovary is more than 10 times the normal size and was causing bleeding and constant pain. So doing nothing in this case was not an accepted treatment alternative. That could be contrasted with Reibl, where Mr. Reibl could have waited a few more years till he obtained his pension before undergoing the surgery. Moreover, in Turkington, the plaintiff failed to establish that the alleged failures to inform her would have altered her decision to have the surgery. The court stated that a reasonable person with an ovary 10 times larger than normal, who was experiencing pain and bleeding for 6 weeks, would have had the surgery, even if informed of the 1 in 100,000 risk of bowel injury. Again, contrast this with the failure to disclose in Reibl, where the court held that had it been disclosed, Mr. Reibl would not have gone under the knife. In Bowman and Sonnen, the defendant surgeon transected the plaintiff's uterus during a laparoscopic assisted vaginal hysterectomy. And due to this complication, the plaintiff had to have urine drained from her bladder into a plastic bag for several months until a remedial surgery could be performed. The plaintiff here sued the defendant on several grounds, including the failure to obtain an informed consent. After meeting with the plaintiff to discuss the procedure, the defendant told the plaintiff's family's doctor that he had reviewed it and its possible risks and that she had wished to proceed. Here the defendant had no notes or specific recollection of his discussion with the plaintiff, but he testified that it was a standard practice to explain the risks of bleeding, infection, and injury to the bowel, bladder, and uterus. Here the judge accepted the plaintiff's testimony that she had only been informed of the risks of bleeding and infection. This, a topic we won't cover this year, is why it's really important for having accurate and full notes taken during any consultation, particularly ones where there could be a consequence. The judge here concluded that the plaintiff would not have had the surgery if she had been adequately informed and therefore held the defiant liable. Here, the defendant appealed on several grounds, including causation. The Court of Appeals stated that causation in informed consent cases includes both that subjective and objective component. Here, the plaintiff was not asked what she would have done had she known the 2% risk of damage to uterus. Thus, with respect to the subjective component of the causation test, there was no evidentiary basis for the judge's conclusion that she would have foregone the hysterectomy had she been informed of the risk. In any event, the judge did not consider the objective component of the causation test, namely what a reasonable person in the plaintiff's position would have done if adequately informed. So the Court of Appeal overturned the trial judgment and ordered a new trial. What happens next, by the way, here? I don't know. I haven't looked into it. It's very likely it could have been settled. It's very likely that the plaintiff just withdrew. So even when there are decisions, it doesn't mean there's a positive outcome. Now finally, in Lang and Sekundiak, the defendant orthopedic surgeon had replaced the plaintiff's hip using a new and unproven component that hadn't been licensed for use in Canada. And when the surgery failed and 2 additional operations were required, the plaintiff sued the surgeon for failing to obtain an informed consent. In dismissing the plaintiff's actions, the judge stated that the surgeons have no blanket duty to inform patients of specific medical devices that are to be used in any procedure, and that the surgeon had no duty to inform the plaintiff that the components had not been licensed for use in Canada, and the plaintiff appealed. The Court of Appeal overturned the judge's ruling on informed consent issues. The duty to inform has expanded well beyond what Reibl and Hughes established. Physicians now must disclose not only the risks of a proposed treatment, but also any potential information that's material that a reasonable person in the patient's position would want to know. The trial judge erred here by adopting what was deemed to be a doctor-centric approach as opposed to a patient-centric approach. And the court concluded that the defendant had a duty to inform the patient of the specific components that were to be used and the fact that they had not been licensed yet for use in Canada. Doctors are also required to disclose other things, including errors and incidences. The College of Physicians and Surgeons of Ontario provided advice on the disclosure of harm. Here, harm is defined as an outcome that negatively affects a patient's health or quality of life. Harm may or may not relate to material risks, however. It could be, but it doesn't have to be. And physicians are obligated to disclose harmful incidents as well as no harm incidents. A no harm incident is an incident with the potential for harm that could reach the patient, but with no discernible or clinically apparent harm resulting. In other words, something went wrong, but nothing actually happened to damage the patient. Doctors are also required to consider disclosing near-miss incidences, which are literally defined as close calls. And this disclosure is to be made to the patient, or if they have one, their substitute decision maker, or in the event that a patient has died, it has to be disclosed to the patient's estate. It's supposed to be made as soon as possible, and the college identifies the kind of information that has to be disclosed. The CPSO also suggests that physicians are required to consider whether an apology is appropriate. You'll recall that the Apology Act makes it clear that an apology does not constitute an admission of fault or liability. In Robson and Craig, the court interpreted the Alberta Apology Act, which is very similar to the Ontario legislation, in a narrow fashion. The factual content of the letter in issue, when stripped of the words apology, was deemed admissible because the balance of the letter contained factual admissions relating to liability and therefore was not excluded. But let's return back to Robertson's contention that 20 years after Reibl, things were still going badly for patients. That was over 20 years ago. So what about 40 years later? Are patients faring better now? When I was a kid, I was sleepwalking or walking with my blanket and I fell down the stairs and I broke my arm. What would you do when you break your arm? You go to the doctor and you expect them to do their job, and then you'll feel better sooner or later. But what would happen if your doctor doesn't do their job correctly? What are your next steps? A negligence suit? This has been the case for many patients of BC doctor and surgeon Dr. Tracy Hicks. Dr. Hicks is an orthopedic surgeon who practiced in Langley, BC, and in his long career has had various and numerous negligence cases brought against him, including adults and children with all sorts of grievances. In the worst cases, some of these patients have been left with permanent issues. Usually with as many issues as Dr. Hicks has faced, this would have resulted in his license being suspended and revoked. This would be the responsibility of the College of Physicians and Surgeons of British Columbia. But that doesn't always work. In fact, in 2014, the college was sued for failing to suspend Hicks' license. But that claim was dismissed by a judge who said there was no breach of fiduciary duty here, that legal and ethical obligation to act in the best interest of another party. So, as best is known, he's still operating and treating patients today. Is this a failure of justice? Well, let's consider the case of Max McKee, who injured his arm in 2006 after falling from a kitchen cupboard when he was only 5 years old, around the same age when I broke my arm. Mr. McKee was given a treatment for his fracture at Langley Memorial Hospital in British Columbia by Dr. Hicks, who failed to correctly fix the bones before putting them in a cast, and this left McKee with a permanent deformity. Mr. McKee's right forearm hangs from below the elbow when he holds his arm out to the side. Now, this didn't go to court until 2023, and now the 21-year-old Mr. McKee stated that the job he was working at as an electrician required him to constantly twist his arm, screw in light bulbs, and things like using a screwdriver that left him uncomfortable on a daily basis. And the issue here wasn't whether or not Hicks was negligent. His treatment did not adequately reduce or fixate the fracture, which resulted in the malunion of the bones. So it wasn't about negligence. The issue is about the impact of the deformity. And Dr. Hicks' position was that the deformity, while having some functional impacts, was not progressive, and therefore the damages here should be minimal. Now, ultimately, McKee was awarded over $360,000 in damages, but this was only after 15 years. And this is just one story. The CBC discusses an article that was a front page expose by the Vancouver Sun reporter Rick Houston. Hicks didn't agree to an interview for that article or the CBC article, but the lawyer had told the newspaper that at the time he had performed about 30,000 surgeries and had many grateful patients. But the center of that investigation was the 1997 death of 17-year-old Heidi Klompas. Heidi's legs were broken when a drunk driver plowed into a group of teenagers at Stokes Pits in Surrey. Hicks was the orthopedic surgeon on call for emergencies when Klompas was taken to Peace Arch Hospital in White Rock. The girl's mother, Catherine Adamson, questions whether Hicks is partially responsible for her death because he didn't appear at the hospital until about 7 hours after he was asked to come in. Miss Adamson, in a recent interview, said that Dr. Hicks' career should have ended around then, but he keeps going. Now, to be clear, a 1999 coroner's report did not lay blame at Dr. Hicks' feet for the death, but says that the proximal cause was something called a fat embolism. That led to a seizure that put Klompas into a coma for the rest of what was her short life. A fat embolism is a rare and sometimes fatal condition where the fat from bone marrow leaks into the blood after bones are broken. And the coroner's report notes that the best prevention of the fat embolism is quick treatment of long bone fractures. The attending physician on the night of the crash told the coroner she had made 4 calls to Hicks expressing extreme concern about Klompas' need for an assessment. A nurse on duty corroborates that version of events, but Hicks claims he could only recall 1 phone call. Adamson, Klompas' mother, filed a complaint about Hicks with the college, but it was dismissed in a letter that told her there was no requirement for Dr. Hicks to have attended the hospital immediately. If you're on call at the hospital and you take 7 hours to show up, shouldn't you be liable? Think about that in relationship to Boyd and Eddington, where Eddington went back to sleep while on a long shift as the only attending physician. Consider this in relationship to Boyd and Eddington, where Eddington's decision to go back to sleep and not attend to a patient resulted in his being found negligent for that and among other reasons. But here, Hicks, despite being the doctor on call and receiving 4 calls, identifying the need for immediate assessment, isn't liable because there's no duty to immediately show up. In any event, decisions from the Hospital Appeal Board revealed that both Langley Memorial Hospital and Pete's Arch Hospital attempted to restrict Hicks' privileges over the years with mixed results, although in 2013 there was a decision to remove Hicks from the Peace Arch regular emergency on-call schedule. But consider the story also of Leona Belknap, who fractured her hip in 2014. Dr. Hicks attended to her injury and with her consent performed internal reduction and fixation surgery to repair her hip rather than replacing all or part of it. Ultimately, however, Belknap underwent a total hip replacement 2 years later. And she sued, claiming not only a negligent surgery, but a lack of informed consent and negligent post-operative care. Now here the judge didn't find that Dr. Hicks' negligence was the sole determining factor, but rather one of several causes that contributed to the injury. But he was negligent, but just was a minor factor. For Miss Belknap, of course, this was a major and life-changing event. At the end of the trial, the judge allowed the claimant part and awarded $55,000 worth of damages to the plaintiff. Now, you might think that $360,000 and $55,000 is a lot of money, and in some ways, of course it is. But despite both of these cases being a win for the plaintiffs, McKee and Belknap did not necessarily make that much money. This is because of all the legal costs associated with a lawsuit. Now, there are three main challenges in bringing a negligence suit forward: the cost, the time, and the evidence. And the evidence, of course, requires time to accumulate and gather, and importantly, more money. So if you have access to money or funds, you might be able to bring a negligence suit and possibly reach some form of justice. But if you don't have the cash, you're not going anywhere. So why are the costs so high? Well, first, there are legal fees. Lawyers cost a lot of money and often take a percentage of the settlement that they achieve for a client. There's also court costs, things like filing fees, serving subpoenas, getting court transcripts and videos, all which can accumulate very quickly in terms of the needs and may be unavoidable but come with a hefty price tag. And then, of course, there's expert witnesses. Expert witnesses play a huge role, especially in personal injury and medical malpractice cases, because of the level of knowledge required to make opinions in these situations. Medical experts charge significant fees for reviewing medical records, preparing records, and appearing in court. They may have a fee of up to $6,000 to $10,000 per day and may be required for multiple days. And then you have to pay to obtain the medical records in the first place. And these are essential for building a personal injury or medical malpractice case, as they provide the evidence as to what happened, the injuries, the treatments provided, the notes that have been taken, and anything that happened during the recovery period. And there's costs associated with the discovery. This is the phase in personal injury litigation that involves gathering evidence from the opposing party, and that all comes at a cost. It could include depositions, interrogations, requests for documents, and these all have their own costs. Depositions, for example, require court reporters to transcribe the proceedings. Court reporters have a certain minimum charge for appearing, as well as a charge for their time, and charges based on the number of pages produced during the deposition. And then you better hope you live close to the court, because otherwise you're paying to travel and time off work. Travel expenses may include more than just transportation, but accommodation and meals, and trials can last for weeks, which means there can be substantial costs over time. And if the court decision is not in your jurisdiction, you're not only traveling, but so may be your lawyer. For example, going to a court of appeal decision that's not being held in your city. So what happens to justice if you can't afford it? And realistically, it's sometimes not even worth going to court. Legal fees often greatly surpass anything you could ever make back. Consider the average payout in the US right now for injuries. It's quite low considering how much it could cost to achieve an outcome. Something like a neck or back injury, which is a very severe injury that often has lifelong impacts and could impair a person's ability to do a job, it might only be worth $50,000. So the damages that McKee and Belknap obtained look much smaller when you realize how much money went into getting a lawyer to get to those judgments. And if you can't afford it, you just have to suffer the consequences of your doctor's negligence. And this is the case for many patients, as cost is often the biggest barrier to any person trying to achieve justice. And it's not just in negligence, of course. This can have huge implications in all areas of law. Consider, for example, a man in BC who lost custody of his kids for years, but because he could not afford a lawyer in his case. Here, the BC Court of Appeal had found that a Supreme Court judge's decision had been influenced by a fraudulent expert witness, despite the fact that that expert lacked credentials and never actually interviewed the father or the children. The father is quoted as saying, "I was left with the decision. Walk away because the allegations are meant to destroy you. And if you can't litigate, then walk away. Give up and you'll never see your kids again. Or fight and do whatever it takes, including showing up every single day in a suit, pretending to be a lawyer." The result for this dad was that they were separated from their father for 5 years. And paying for a lawyer is so expensive because you have to pay out of pocket. And if you can't, your options are limited. Maybe you'll have access to legal aid, or perhaps someone will take the case on pro bono. But you might also find yourself like this dad who had to represent himself. And experts in opining on this case said it could have ended very differently if the father had his own counsel. This is often the fate of people who cannot afford to dish out tens of thousands of dollars for legal assistance. And to be clear, this is also my case. I recently lost my case. The reason being is that I was filed with a new motion about 30 minutes after Jovi died, and I simply didn't have the capacity to address it. I kind of just gave up. To be honest, I think it's an awful, corrupt, disingenuous, distorted, toxic system. The courts are not about justice and they're not about law. But I also simply couldn't afford a lawyer. Think about that. I teach law and I couldn't afford a lawyer. I have 3 law degrees. I teach in a law school, and I couldn't navigate this system easily on my own. I was overwhelmed by it, and given my current circumstances when Jovi passed, I just couldn't do it. And now I lost. Some form of justice. As long as you can pay for it, you're going to win. And we know that this is the case. And the reality is that people who tend to need legal aid services often are those that have lower incomes and could never afford to hire a lawyer in the first place. But let's be realistic. Most people can't afford to hire a lawyer. It's a good thing that in 2024, Legal Aid Ontario increased the financial eligibility thresholds to be able to obtain their services. And the income threshold has now been raised to $45,440 for families of up to 4 people. But that leaves a whole bunch of working class people and professional people who can't afford a lawyer and do not qualify for legal aid. And if you think about it, like, how can you afford to pay for a lawyer? Let's put into context, if you work at a minimum wage and work 35 hours a week, you're going to make roughly $34,000 a year. The average cost for a 1-bedroom apartment in London is $1,400 a month, which means you're spending almost half of your yearly earnings just on living, having a place to stay. This is hardly livable, and certainly not possible to do if you have to hire a lawyer. And then you have to realize that even if you could afford a lawyer, having a $600 per hour lawyer or more on a small claim isn't worth it. It might be justifiable for a $5 million lawsuit, but what if you only have small injuries, $10,000 or less? That doesn't mean it's an insignificant injury, but you could end up paying more in legal fees than you'll ever recover. And you wouldn't even start proceedings, to be honest. That $10,000 injury could be very significant. The 2023-2024 injuries from the WSIB in Ontario note that the average cost for a claim involving a finger was under $2,000. Now, when I was 16 or so, my uncle cut off his thumb with a circular saw. It was wet wood, the saw got bunged, it popped up, and it knocked down his thumb, cut it off in 2 places. He picked it up, put it in his pocket, drove himself down to Grand River Hospital, and they stitched it back on. He had a choice to make. Have the thumb put back on in about a 10-hour surgery, although it would not be really functional, he'd have no feeling in it, or they would compensate him through insurance $10,000. What would you do? 10 grand or a thumb? The reality is that the payouts aren't huge. Now, that was insurance, but it's not so different in the courts. you're not going to really get what you think for. Now, a person that's making, $45,000 a year who might lose the ability to use their fingers because of a negligence claim may never ever be able to get recovery because it simply won't be affordable, and they can't afford a lawyer in the first place because a lawyer comes straight out of the pocket of the plaintiff. Now, as a result, justice really isn't achievable for most people who have experienced medical negligence. Cost is a major factor, if not the most relevant one. And more often than not will be the reason people don't even begin to seek out legal help. Or if they start, it might be why they lose because they run out of funds and can't continue. And then there's the issue of costs. And here I'm referring to legal costs, which is a specific category of costs that the courts award the winning party in terms of the losing party has to pay the lawyer fees and disbursements, legal costs of the winning party. So if you lose in court, you pay more than just damages. Now, this is supposed to deter unwanted lawsuits, but I no longer buy it because it's used to convince people to go into a court decision that don't worry, if we win, the other side will have to pay the costs. It's also used to bully people. Do what I want or I'll take you to court and go after costs. I think it's a real problem, and I think we really need to assess this. But of course, it's in lawyers' interests. But it's also a real problem when you're fighting a Goliath, someone who can absorb the costs, someone like, the CMPA. As you recall, the Canadian Medical Protective Association is a defense association that protects doctors and surgeons in courts, and it is a multi-billion-dollar organization. Now, the CMPA has a big role to play in safety and other things. We've used their materials this year, but they're also really just an entity meant to protect physicians in medical legal issues. In their 2023 report, the CMPA notes that they engaged with members 49,000 times, responding to 29,000 unique requests for medical legal assistance, and of this, almost 21,000 of them were requests for advice, and just over 8,000 were new medical legal case requests. Now, in 2023, the CMPA provided medical legal support in 979 legal cases, just over 5,000 college matters, which includes things like complaints and discipline, and just over 2,000 hospital matters. And they note that they paid out $308 million in compensation to patients that have been harmed by negligent medical care, and that this was the highest amount ever paid in patient compensation in 1 year. The highest ever. But let's have a little bit of a closer look. In 2023, the CMPA reports that there were 13 judgments for plaintiffs. 13. There were 33 for physicians and 322 cases settled, and more than 623 cases were dismissed, discontinued, or abandoned. And those aren't parsed out because dismissed suggests that the courts dismissed it, where discontinued and abandoned means the plaintiff couldn't continue for any number of reasons, and undoubtedly costs would be one of them. And 13, that's pretty good. 13 is the highest in 5 years. There was only 5 cases for plaintiffs in 2019. 5 cases out of 775 legal actions that year. Things that had some traction. That was less than 0.65%. In 2023, it was higher, 13, but that was only 1.3% of cases that were brought before the courts. And that's only 1.3% of cases won for plaintiffs that made it somewhere. But let's be generous here and let's do some math real quick. Over the 5 years, the CMPA reports there were 45 decisions for plaintiffs of a possible 4,357. But to be fair, let's include the settled with category here, as in a settlement, a plaintiff gets something, although we don't know what. And I'm not sure we should include these as wins, certainly not for the public system, and probably not wins all the time for the plaintiffs. But in any event, let's now call this 1,522 wins. At 45 decisions for plaintiffs out of 4,300, that's just over 1%. At 1,500 wins out of 4,500, that's about 36%. And this is much better, of course, because it's 1/3 of the cases. But 1/3 of what? This is the actions that were actually started. So what if we used the CMPA's own designation of total new medical legal cases possible, which includes those that were not submitted or involve threats or hospital matters, etc. And suddenly now it's 1,522 cases for the plaintiffs, including those settlements, of a possible 42,396. The wins now is about 3.5%. So clearly, as Robertson noted, plaintiffs are doing badly. And it's not just the legal tests, it's the entire system. And as we are well aware, many people never even come forward, whether they're not injured enough, they don't know their legal rights, it's out of fear or retaliation fears that the doctor won't serve them, or realizing they couldn't afford it, or it's not in their nature. Most lawsuits don't even make it to the front door. And yet only 3.5%, if we're honest, wins for the plaintiffs even get there. So in short, there's hardly justice in medicine in Canada. But don't worry, there's some good news. For some people, of course, because lawyers make a lot of money. In 2023, lawyers were paid almost $225 million. That's about 73% of what patients receive for being harmed. And it's not because of a lack of money. The CMPA's investment portfolio is worth $5.6 billion. By the way, the CMPA is a not-for-profit, unless, of course, you work for them. I wonder how that makes you feel. Of course, physicians need to have legal protection, but what do you think when you realize that you will have to pay for your own lawyer, and if you lose, potentially for the CMPA's cost, for an injury in a system that you have no option but to rely on, that you pay out of your own pockets with tax dollars already, to pay publicly funded employees in a public system overall, and yet you are now left with the costs of trying to demonstrate that your physician was negligent. This is why there's been calls for no fault or other systems of liability, because it's clearly not working. If you're a patient injured by or in the healthcare system in Canada, justice is not realistic, and it's likely not even possible. And my friends, that's a problem. Justice should not be illusory. Justice should not be dependent on whether or not you can hire a highly paid, trained lawyer who has put a capitalized kind of restrictive domain of their own area of practice that no one else can come into. They make all the rules, they set all the fees, they influence all the decisions, and yet patients suffer. I don't think that's access to justice. My intention has always been to have this be a late night show, and I wanted to have live guests, and I wanted to have performances with Western students, bands and comedians like you'd see on a late night show. So with that in mind, tonight I present to you a band that we decided to call tonight Church Band.
1, 2, 3, 4.